So, I have a question. Are you a judge? You don't have any jurisdiction over me. I would argue you don't have any jurisdiction, okay? No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of the trust. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Or
I
you may
object. I
walk
will
a
not be
cash
paying
check or
any fine.
charge into the
I will not be
44th
paying
District
any fine.
Court. Please don't interrupt the court, sir.
Today, we're tuning into a virtual courtroom session that turns into a lesson in patience and authority. A defendant who identifies as a sovereign citizen is contesting a red light violation. The case itself should be straightforward. The officer who witnessed the incident is present to testify, and under state traffic laws, that testimony usually carries a lot of weight. But instead of addressing the facts, the defendant launches into a string of unusual arguments that have no legal basis. It's the kind of performance that makes you wonder if he actually believes what he's saying or if he's simply trying to stall. Either way, what makes this hearing so compelling is how the judge responds. Let's break it down together.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of the trust.
Very well, Mr. Mathis. Today's the date and time for your informal hearing. The citation before the court, Mr. Mathis, indicates that on May the 24th of this year at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color, on 11 Mile Road, air near Washington, in the city of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr. Mathis, you have three options and three options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this manner. The court will attach the scheduled fine and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility, and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by law.
No, I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Urick, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very well. Officer Moran and Mr. Mathis, please raise your right hands.
I do have a question.
Do you solemnly swear the testimony you shall give before this court shall be the truth, so help you God?
I do.
Thank you very much. Please proceed.
Before we get into the officer's testimony, I have to point out just how skillfully this judge manages the courtroom. He doesn't get flustered, doesn't engage in back and forth debates, and simply stays focused on the matter at hand. That calm, no-nonsense approach is exactly what's needed when someone is determined to test the court's patience. Engaging too much with baseless claims often just fuels them. But here, the judge's restraint keeps the process moving forward without giving unnecessary attention to arguments that don't belong. It's a kind of quiet firmness that says, we're here to deal with the law and nothing else. Personally, I think it's the best way to handle a situation like this. What about you? Does this judge's approach work? Or would you prefer a more direct shutdown?
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge, black in color, with Michigan plate Edward John Lincoln 6501 I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
With respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, magistrate, at that
And
time.
that's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
So, I have a question. Are you a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So questioning the court's authority.
You don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay.
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
At one point, the defendant insists that the court has no jurisdiction over him, a common refrain in sovereign citizen cases. But here's the contradiction. If he truly believed that, why even show up to the hearing? The fact is, state courts clearly do have authority over traffic matters, and that includes enforcing laws designed to keep roads safe. Arguments about no jurisdiction collapse the moment they're raised, because the legal framework is firmly established. What's striking is how often these claims appear across the country, as if repeating them will eventually make them valid. It leaves us asking whether people genuinely misunderstand the law, or whether they're using it as a convenient excuse to avoid responsibility. Either way, this hearing is a reminder of just how persistent and ineffective those claims can be.
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or are you asking where it is in
Right
terms
now.
of who's present on behalf of the city of Royal Oak?
Where is the city of Royal Oak? Please bring the
Court doesn't understand your question. Are you asking where it is on a map, or where is the officer?
No, I know exactly where it is on the geographic location, but where are they right now?
The officer is representing the city of Royal Oak as a sworn and certified Michigan peace officer. So what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay. Well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written
Well,
under the vehicle code
as I
of the
was
city of
traveling,
Royal Oak as it is adopted.
as I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Another misunderstanding the defendant raises is that traffic offenses require a specific victim. That's not how the law works. Violations like running a red light are considered offenses against public safety, not individual people. The state itself steps in as the party bringing the case, because the risk created affects everyone on the road. You don't need a car crash or an injury for the offense to matter. The act of ignoring a traffic signal is enough to endanger the public and justify legal action. These rules exist to prevent harm, not just to punish it after the fact. So while the defendant tries to argue otherwise, the law is very clear, and the judge wastes no time reinforcing that point.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward as far as the injured party. No one was injured. You guys.
Mr. Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case
Why are you
under
trying
the
to
Motor
charge
Vehicle
me?
Code, as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
No, it isn't. If you guys can't bring any injured party,
Very
no
well.
injury. You guys are
Officer Moran, any rebuttal testimony?
No rebuttal testimony.
Thank you so much. Mr. Mathis, the burden of proof in a civil case is a mere preponderance of the evidence. The officer, a duly sworn and certified Michigan peace officer representing the city of Royal Oak, which is one of two cities upon which this court has jurisdiction, has put his testimony forward. There is nothing in the record that has rebutted any of it. Therefore, the court is finding you responsible for the citation as it was written. The fine for that serves $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into the 44th District Court. Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis. If you take exception to the court's ruling, you may post a bond in the amount of $175 within 7 days, and the matter will be placed upon the formal hearing docket of the chief judge of the district, and at that time, the city of Royal Oak would be represented by a city prosecutor.
In the end, the judge hands down a fine that's both fair and consistent with state law. In Michigan, violations like running a red light are treated as civil infractions rather than criminal offenses, which means they're resolved through fines rather than jail time. The purpose isn't just punishment. It's about encouraging safer behavior and protecting the public. What stood out most in this hearing, though, was how the judge never allowed the courtroom to spiral out of control. He refused to be distracted by irrelevant arguments and kept the focus exactly where it needed to be. Part of me wonders if contempt of court might have been justified here, given how disruptive the defendant was. But even without it, the outcome sends a clear message. The law applies equally to everyone, regardless of personal beliefs. The bigger question is whether the defendant will actually learn from this or continue down the same path. Do you think this was a fair resolution, or should the judge have gone further?